Hello, class. This is Jessie Nunn the third, tuning in or checking in for the industry expert review. I decided to listen to one of the podcasts on the Entertainment Update Law website. So I'm going to go ahead and just jump right into what I ended up learning listening to the two speakers. The first thing I came across was public domain. Public domain is the state of belonging or being available to the public as a whole and therefore not subject to copyright. Works in the public domain have expired exclusive intellectual property rights. Um, the two speakers, they spoke on a character named Buck Rogers. Um, and they spoke about a film producer named Don Murphy who was trying to use the character's name and likeness for a film, but a judge rejected his bid to have Buck Rogers declared in the public domain. Um, to me, this case is absolutely crazy and out of the ordinary. The only way for Don to clear the rights for the film is if he potentially violates them, which is absolutely just crazy. Pretty much, Don Murphy would have to put together his whole entire film, spend millions of dollars, release it, and hope that it doesn't get him in trouble. Um, Buck Rogers isn't the only character that's been wanted for new films that filmmakers feel should be in the public domain over the past few years. Zorro and Sherlock Holmes have also made the list as well. It sounds like we could use some more clarity with this subject overall. That's a picture of Buck Rogers and his crew. The next thing I came across was copyright infringement. Uh, Copyright infringement is the use of works protected by copyright law without permission, infringing certain exclusive rights granted to the copyright holder. For this movie, the Good Lie is a Reese Witherspoon movie. The plaintiffs in the case came forward with edgy theories about why, when they sat down with screenwriter Margaret Nagle Black back in 2003 and shared their life stories, they were entitled to be deemed joint authors of the taped interviews. They also asserted a breach of a joint venture agreement, fraud, and more stemming from the way they were promised compensation from a producer. Ultimately, if these refugees couldn't get adequate compensation, they demanded an injunction on The Good Lie, alleged to be a derivative of the interviews and the screenplay they claimed to co-own. The Judge May came to the amazing conclusion that she may grant injunctive relief despite the Sudanese refugees' inability to register for a copyright. The judge ruled that claims of an oral agreement concerning a joint venture were sufficient, stated, to survive a motion to dismiss. Likewise, the judge allowed a claim of fraud to proceed to cover the representations the film companies made in getting the refugees to share their life stories. The next thing I came across listening to the podcast was defamation of character. For the movie Straight Outta Compton, Marion Hughes Suge Knight Jr. sued Dr. Dre and Ice Cube. He claims the portrayal of his character is inaccurate. I got a quote from him online, and he stated, "Y'all know Dr. Dre ain't built like that." Or he said, "The entire story was BS. You think I let Easy E get off that easy? I beat that man within an inch of his life before he signed those papers. I was knocking dudes out daily. If they are going to show Suge, then they need to show the real Suge. I've been the realest gangster in this biz from day one, and I'm gonna be the realest until the casket drops." And his lawyer quoted that as well. When they took it to court, the judge knocked out the key claim for $200 million, and because Suge didn't have much proof of anything. The next thing I came across was Serial trying to trademark their name, but was denied because the name was too descriptive or suggestive and overall too generic. Um, and the last thing I came across was copyrighted links for Playboy pictures. Um, Melchior Wathalit states, and I can't say that name at all, as a general rule, internet users lack the knowledge and the means to verify whether the initial communication to the public of a protected work freely available on the internet was done with or without the consent of the holder of the copyright. If internet users risk liability for copyright infringement every time they place a hyperlink to works which are freely accessible on another internet site, they will be much more hesitant to post those links. So pretty much anything shared should not be infringed upon. or count it as copyright infringement because we're just sharing links online. Here are my references, and I hope you got something out of what was said. Thank you.